Welcome, everyone. We're just having people enter into the Zoom here. We'll wait a little bit to make sure everyone gets situated. No, Bridget, if you have a way of telling if everyone is all set inside and give me the okay to move forward, I'll do that.
Few people still joining.
Yeah, we'll wait a bit.
All right, I think if you want to get going.
Okay, great. So, hello, everyone. Welcome to Eviction Defense, Advice and Full Representation. So this is a presentation. We're going to be talking about eviction cases and how to defend them, and going through all of the aspects that deal with that. We have a CLE code that we'll be giving out. Bridget, put that in the chat. This has been approved for one standard CLE credit. I am Sebastian Ellefson, and I am one of the housing program attorneys with the Volunteer Lawyers Network. All right. So a little overview about the Volunteer Lawyers Network, just for those of you who are not familiar with us. Great organization. We've been around for over 50 years in one capacity or another, and we are here to promote and protect the rights of low-income Minnesotans through the power of legal volunteer service. We have a number of areas of practice that we do besides housing, which is what I do: family law, civil matters, bankruptcy, immigration, criminal expungement. If you have a low-income individual who needs some free legal help, send them over to our intake line, and if we can't help them, we will send them over to someone who can. And what we do generally, we screen all of our callers to make sure they're income eligible, and then we connect them to volunteer attorneys to either give them advice on their situation, or in some instances to have full representation on their cases. And for those volunteers, we provide training, support, and malpractice insurance. And this, of course, presentation is one of those trainings. And just to know that we here at VLN, we have basically two different clients. One is the low-income individuals who we assist, but then the other is the volunteer attorney network that we have. And we really do, our job is to help you be a good and successful volunteer. So always know that, always feel free to be able to reach out to us for help, ask questions. We have resource attorneys to help you every step along the way. We really want to make sure you're successful. So big picture, like, what do we want you to be able to do at the end of this presentation? So, like, what's coming your way? Some of the things that you're going to be able to do after this, you're going to be able to know about and navigate Zoom court. I know that was a thing that, some people are a little hesitant about. They don't know what's happening there. And then more specifically to evictions, you're going to be able to spot service issues in eviction cases, to be able to name all the different bases for evictions and some of the standard defenses to those bases for eviction. You're going to be able to negotiate a good settlement, know, what makes a good standard settlement for someone in a defendant in an eviction case. And of course, know how to reach out and get support from VLN so you can take your first case or sign up for an advice shift, which of course we always are looking for more volunteers to help us with that, because there is a ever-flowing stream of people in need of eviction defense. All right. So, and here's an overview of the specifics of what I'm going to be presenting here. First, I'm going to be talking about the timeline, case overview, talk about Zoom court. We'll talk about those service issues, move into settlement negotiation, then get into underlying bases for evictions, and lastly, talk about the specifics of discovery, evidence, and going to trial. Get you some good trial tips. Let's dive right in. All right, an eviction case. You see a nice timeline that we've created here. And step one, and this is an optional step, does not need to happen in Minnesota, except for in certain jurisdictions, is notice of filing. Many states have a required notice. You need to let the tenant know, we're going to be filing eviction for you in X number of days for this reason. Certain jurisdictions in Minnesota, that is required. City of Minneapolis being, of course, one of the big ones. St. Louis Park, a suburb of Minneapolis, also requires that. And this is something that's, can pop up around. So it's always good to check if you're, practicing in a different area. You can always check that. You can always ask us, what are all the list of all the cities that require this? Or the notice may be required. Otherwise, it's possible. It's like a requirement in the lease, but in Minnesota, it's not that common of a thing. But then you have the filing of the eviction action itself, and then in the service of that eviction action. And these are heavily regulated by statute of how this filing occurs and how the service needs to occur. And of course, we're going to be talking about those service requirements. But that's how your client is going to find out that they're being evicted. They'll get a notice, a summons, and telling them to come to Zoom court. It's going to have that Zoom login information there. And then you have the initial appearance, and that's where that arrow is pointing at. That's really where things start. And that's where we at VLN and you as a VLN volunteer may first really come into this case. We are present at every initial appearance calendar in Hennepin County, Ramsey County, and Anoka County. We have either staff or volunteer attorneys there to give advice to people as they come in. And this is where we usually first run into a case. If someone does contact our office before the initial appearance, we get that on occasion. People call like, I got an eviction notice. What do I do? If it's only a couple of days out from that initial appearance, we're not even going to give them advice. We're just going to say, just go to your initial appearance. There'll be an attorney there who you can ask for a free attorney. They can give you advice. And that's usually what we do. If it's long enough beforehand, we might sign them up for an advice shift, but that's frankly quite rare. So at the initial appearance or afterwards is where you will likely be encountering these situations, at least through VLN. And then things move quickly, as mentioned here. Eviction actions are summary proceedings. So right away, then after that, the next thing is if the case is proceeding forward, there's going to be a trial set. There's going to be a discovery deadline set, and the trial is held. And it's a rather fast matter. Usually within a week or two after that initial appearance, that's when the trial is going to be held. And then they have the option after that of judicial review here in Hennepin County and Ramsey County. These matters are held by judicial referees rather than district court judges. You can automatically have that appeal the issue to a district court judge for judicial review. And then, of course, you could always then, if you don't like that, appeal it to an actual appellate court. I don't see that very often. And then the last step in the eviction timeline is the issuance of the writ. If the landlord is successful and they are awarded possession of the property, they are awarded a writ of execution, or sorry, writ of recovery, and they can execute that writ by getting the sheriff to post it on someone's door. They have 24 hours after that, and then the sheriff's deputies can come and physically eject individuals from the residence. And just general rules, general overview, like I said, these are quick proceedings. They're all governed by Minnesota Statutes 504B. It's a relatively short chapter, so you can read through all that in one sitting and get a general scope of the rules. In Hennepin County and Ramsey County, it's also governed by Minnesota's Rules of Practice 601 through 612. So you want to familiarize yourself with that as well. And I did not mention, just as a reminder, if you have questions as we're going, feel free to type them into the chat or the Q&A. The chat will be public to everyone. The Q&A is just viewable by myself and my assistant Bridget, and we will read those and I'll answer your questions as we go. So please do let me know. All right, so Zoom housing court. If you haven't been to a Zoom court, which a lot of people have not, this is what's been going on, during the pandemic. And still, as of today, all initial appearances, I think throughout the state, but certainly in Hennepin, Ramsey, and Anoka County are all conducted on Zoom. And most, if not all, subsequent hearings, including trials, are still conducted via Zoom. I can't speak to outstate if that's still the case, but to my understanding, it is. So there's a Zoom link within the summons itself. It'll say, you go to zoom.gov and you type in this meeting ID, you type in this passcode, and then you get into the Zoom hearing. Please do log in early. Tell your clients to log in early to make sure that there's no problem with their internet, because that's going to cause problems. If there is some sort of issue where they can't log on, or if their internet goes out in mid-hearing, you can always call into the Zoom meeting as well. There's a telephone number, an 800 number. You again enter in that passcode and that meeting ID, and you get in audio only version of Zoom, which is perfectly acceptable, certainly for an initial appearance. They do not like you to do audio only during a trial, although if that's the only option, I think most judges will allow it. But what happens when you're actually in the initial appearance, Zoom itself, what is it like? There's different breakout rooms, which you've probably seen through your other use of Zoom. Usually, at least in Hennepin and Ramsey County, the main room is they call it the gallery, or just the clerk's room, and that's where everyone gathers. The clerk is kind of in charge, and the judicial referee or the judge will come in, make an announcement to everyone, explain what's happening, and then there'll be a separate breakout room, which is the courtroom itself. There'll also be several other breakout rooms that are available to the attorneys to use. You can go into a breakout room to talk with your client, go in the breakout room to talk with opposing counsel, and you're able to move yourself, or if you have trouble with that, or if you're on phone, you can always have the clerk move you around or your client around. So if you're ever having trouble, just talk to the clerk, and they'll, they do this every day, so that they know what's going on. And if you can't find, your opposing counsel, talk to the clerk. Say, I'm in this case. I'm trying to find the counsel, plaintiff's counsel on this matter. Do you know where they are? And they might know, or they might be able to move them. They'll facilitate things. So you'll get used to it fairly quickly. And again, if you have any issues with that, talk to us about it. We are going to have actually another CLE coming up in early May that we are teaming up with the Hennepin Housing Court to run. That is going to be a mock Zoom session, mock housing court. And I think it's going to be a lot of fun. And you can really get in there and just, it's like a sandbox, and just practice, muting and unmuting yourself, moving around, practice, at least see some people sharing the screen to do evidence and so on. So if you do have some concerns, please do attend that session. I think it'll be really educational.
I have a couple questions that came in. One, are the rules of practice different outside of Hennepin and Ramsey County?
Yeah, so the just in general, those rules of practice, Minnesota rules that I cited, 601 through 612, those are just in Hennepin and Ramsey County. And of course, you go to any county or any judge, you could check out their local rules. There are different standing orders. I know Anoka County has its own standing order that is specific to housing court. But I don't know of any thing that would make them be particularly different. I mean, the main difference, if you go outside of Hennepin or Ramsey County, is that you will likely get a district court judge as opposed to a judicial referee. So this will be someone who does not practice housing court, who doesn't use housing law every day. So they might not really be super familiar with the nuances of housing law. So if you're making a very specific argument about, for example, service, there's some case law that is specific to housing court, and you might want to have those rulings at your fingertips, so you can explain to the judge the law. Other matters, I know in 601 through 612, one of the things is motion practice is very relaxed in housing court for Hennepin and Ramsey County. It basically waives any timing requirements in the rules about making any motion. So you can just make any motion you want at court, an oral motion, and the referees will entertain hearing it. And I can't say that is the case in outstate jurisdictions. So that's kind of one that I know that we are very lucky to have, at least from my perspective, in Ramsey and Hennepin. Just go to court, before trial, you can make your motions in limine, or you can make your motion to dismiss, or whatever you're going to have, and they'll entertain it. So I'll leave Zoom court here now, but just to know, if you want to learn more and you feel a little trepidation about it, go go and observe court. You can always just go in and mark yourself an observer. There are plenty of observers in court. You can go witness, trials and hearings and see how what happens there. And if you actually want to come and shadow us specifically and see what we do, we always welcome attorneys to come and shadow and get the experience of eviction defense that way. So please contact us if you're interested in that. My email will be at the end of this presentation, and you can shoot me an email. All right. Service
Another
issues.
quick question. Sorry,
Oh, yeah.
Sebastian.
Yeah.
If this person had a client who's trying to evict their husband, would they need to send notice? Case in Hennepin County in Brooklyn Park.
So the question basically is, does Brooklyn Park have notice requirements? I don't believe so. I think that in Hennepin, the only two are Minneapolis and St. Louis Park. Things can be passed and changed, but I feel like what I've heard about it. So no, if you think that you have a cause of action for eviction, you do not need to provide the tenants any notice of that. You just need to serve them with the summons after you file it in court. And that, surprises and annoys tenants a lot, but no, it's not required. All right. Service issues. This is a big thing to know about for eviction cases, because it's so easy to get the service wrong, especially if you are dealing with pro se landlords. They will very often get this wrong, and it's an easy way to get the case dismissed or similarly use that as a leverage in your negotiations, being like, listen, we could get this dismissed today, so we're going to be asking for a better settlement, and we can just resolve this today. And it's a very powerful tool to have. So the service for eviction cases is governed by 504B.331. Some things to know about it is this case law says that landlords need to have strict compliance with this. So even if there's very minor non-compliance with this, it is a reason for the case to be dismissed. And certainly in Hennepin County, where again the referees are dealing with this every day, they're very aware of the requirements of service and will dismiss a case if they're not followed. You go to Ramsey County, they're they're certainly still aware of them, but they might be quite as receptive. And then if you do get outside of those two, I still make the arguments, but the district court judges might not be as receptive, and that's why it is good to have this case Koski to reference it and to remind the judges that service does need strict compliance. There's 3 different types of service you can have: personal service, substitute service, and the mail and post. Usually not any problems with personal service or substitute service to know, and likely are generally familiar with those. Substitute service, it does need to be at a person of reasonable age. Usually that's ruled to be around 12 or 13 years old. So if you have substitute service on an 8-year-old, you can certainly contest that. But mail and post is where we get our bread and butter for getting these cases dismissed. So we're going to go over this in detail. And it is the statute is convoluted. So have it in front of you when you're arguing before a referee to get this dismissed. And I have a very handy chart that I think makes it visually understandable. So service by mail and post, is it good? They have 2 different lines here. You can see, follow the arrows. Everything on the left has to happen before something on the right of the arrow. So the top line here, service attempt number 1 has to be at least 1 day before service attempt number 2, and one of those needs to be between the hours of 6 p.m. and 10 p.m. People usually get that right, although if they don't, then that's an easy thing to knock this out. And even a district court judge outstate is going to say that, yep, you needed one of them to be between 6 and 10 p.m. That didn't happen. We're kicking this out. The other aspects, this is where people usually mess up. You need to mail the summons and the complaint to the defendant. That needs to be done before they file with the court an affidavit of not found. And both of those need to happen before they post on the door. And those three things, people mess up the order all the time. And that's what the statute says, that mail to the defendant first, file an affidavit of not found with the court after that, post it on the door after that. And of course, the service attempts also need to be before the posting on the door. And then posting on the door needs to happen 7 days before that first appearance. So look very closely at when did they put it in the mail to give the defendant at their last known address, which is likely the address of where they're being evicted from. When did they file that affidavit of not found? It's going to have a timestamp when they file it with the court. And then when is the affidavit of posting for when they post it on the door. And yeah, this is a very powerful tool. And there's unfortunately very few other tools at a tenant's disposal when they're fighting an eviction case. So please pay attention to this. Other issues that you want to pay attention to, I'll just kind of go over these quickly. We at VLN, we have an eviction defense checklist, and you can go to our website, you can download it. It has all this information on a handy checklist form, and literally every time that you're talking to a client at a first appearance or even before then, just go down the checklist and it'll have every single one of these service issues and these other issues that I'm identifying, to just remember to check it. And you know, summons was delivered at least 7 days before the first appearance. Plaintiff's agent. So that's another thing that it can be dismissed. No service on a legal holiday. In Hennepin Ramsey counties, first appearance, you know, again, these are all just like small nitpicky things. You just want to check to make sure each one of them is done correctly. A couple of other where the property was owned by an estate of a deceased individual, and the executor of the estate was bringing the lawsuit in their own name, which is not correct, and that would be grounds for the case to be dismissed, and that led to a better settlement arrangement. And then with all cases, and this is a bit more substantive, but you know, but it applies to everything. Does the tenant have a disability that was not reasonably accommodated? Is the tenant a victim of a domestic abuse? And is this eviction retaliatory? Those are things that can apply to every single type of eviction. So think about those right off the bat. Okay, so let's talk about settlements. You know, maybe you've spotted some service issues, maybe you hasn't. The first thing you want to do is when you're getting a new client, is figure out what do they want to have happen, because maybe the client does not want to try to stay in the unit. That happens a lot. You know, they have a toxic relationship with their landlord. They're not interested in staying, but they have some things that they do want. You know, maybe they can't move out today. They can't move out next week. Maybe they want to get some money to help move out. If you know, there's a lot of things. So talk to your client and figure out what they want. And then beyond that, we have settlement forms. I recommend you use those because it'll help guide your thinking about the things you want to have in that settlement. And the court has settlement forms as well. Again, checkbox style, and also little paragraphs that you can enter. But whenever you're entering a settlement for eviction, you always want to ask and try to push for get an expungement of that eviction. The eviction record starts as soon as the case is filed against the defendants, and right away these organizations that aggregate this information and, you know, provide it to landlords as references for, you know, background checks, that happens the moment the eviction is filed. It's not due to the judgment against them, but just the filing of the eviction. So, and that stays on the record as being filed against them, even if the case is dismissed, unless the case is expunged. So if you get a dismissal due to bad service, make sure to ask the judge, please expunge this case. Or if you're getting a settlement, we want the case to be expunged. And usually the wording of that is, you know, for example, with a move out date, you say, okay, the move out date is going to be on, you know, the end of the month. after the client successfully moves out, they can get an expungement upon the filing of an affidavit of compliance. And you can word it, you could say if they comply, or you could have like if no writ of recovery is issued within 30 days, or however you want to have the triggering mechanism that allows you to file that affidavit of compliance. Other things to ask for that are good, but you can argue over the other side with them, but they're always going to get it's called a neutral housing reference. This way, if the client is looking for new housing in the interim while they're trying to move out of this place, they can use their current landlord as a reference, and the current landlord cannot speak ill of them. Usually that works out as, they get contacted you, they will verify, yes, this person rented from me from these dates to these dates. And if they get asked, would you rent for them again? They could say they're always free to apply, and they won't say anything worse than that. And the last one is marking the case confidential or getting the case caption changed. Again, if you're not going to get the case expunged for 30 days, 60 days, in the meantime, this eviction can get on these lists, or for that matter, landlords, if they're very industrious, would be checking court records themselves, perhaps. But if you mark the case as confidential, then it cannot be found by these third parties. Or if you change the case caption from your client's name to John or Jane Doe, then they won't be able to find. Marking confidential is usually that's an easier route. I mean, if you say case caption change, that kind of confuses some people sometimes. It's even can confuse court personnel who are not familiar with that. I mean, like in Hennepin County, again, they deal with case caption changes all the time. But I've been elsewhere, and I mentioned please can the case caption and the roles, and they're like, what do you mean? And so if you just say mark it confidential, that's an easy way to get what you want. But otherwise, be realistic, be creative. Don't agree to a move out date that your client is not going to ultimately be able to move out on. I mean, or at least go into that knowingly, because if you agree to move a date, you're going to get that expungement, but then they don't move out, then you're not going to get that expungement. And that's going to have some long-term negative consequences for these tenants. And you want to always explain that and be like, listen, we really want to get this expungement. We want to get this eviction off your record. So we need to get a deal that you're going to be able to do. And with some of the clients who I'm involved with, and again, I do this full time and I get paid for it. I follow up with them afterwards, and 2 weeks before move out, I give them an email being like, remember the move out date is the end of this month. Do you have a place lined up? Make sure you're out, otherwise we can't get that eviction expunged. And yeah, creativity. There's a lot of different options. Anything that you and the other side can agree to, and there often are hang-ups. Like the landlord will be hanged up on certain actions that the tenant is taking, and therefore refuses to allow them any time. But if you feel like, what are you afraid of happening? And they say, well, I don't want the tenant to be, breaking the walls anymore, or whatever it is. And you can put in there, okay, then, you're going to give them 30 days, but if they cause damage to the property before then you can ask for a writ before then. And that, you can work in things, you don't want to hamstring your clients too much, but if it's that or no deal, and they're going to lose a trial for certain, then you can work in certain restrictions that'll allow you to make that deal with that landlord. So here's some examples of sort of like what might typically happen. The first one is the poor bargaining position. So this is, your client definitely did what they're accused of doing, and if this goes to trial, they're definitely going to lose, and there's no service issues to save them. Then we're usually looking at a 15 to 30 day move out window. And there might even be some conditions on what the tenant's actions as well. But again, the reason that you're doing that is because you're only going to agree to this if you're going to get that expungement in there, and maybe also get a neutral reference or these other things. Because otherwise, if you're not getting the expungement, there's very little reason for a tenant to agree to a 15-day move out, because they could just take it to trial, lose miserably, but they'll still get that 14 days. So yeah, always push for that expungement. I can't say that enough. Something in the middle where, the allegations that are made are a little bit vague. You could definitely try to fight them in court. Maybe you win, maybe you wouldn't. Maybe there's some sort of defense to try to get this thing dismissed today. Then you got a little bit more bargaining power, and or just if the landlord and the tenant are not, the landlord wants them out, but they're not on totally horrible terms, they might agree to something in the 45 days to 60-day range. Or of course, you can always try to negotiate to have the tenant stay with a payment plan. We don't see as many of those recently because of rent help is kind of taking care of all the non-payment issues, and I'll get into what rent help is in a moment. But soon rent help is going to be a thing of the past, and we're going to see more payment plans again. And so you literally are writing out this much money we paid on this day. You might even specify the time and the method, and it's a very detailed list of like what they're going to pay and when to get caught up. And if they don't stick to that plan, then they can be default of the settlement, and they can be the landlord can get a writ of recovery without going back to court. Another fun option is the fast move out. Unbeknownst to the landlord, the tenant has already moved out. So you want to use this to your advantage and say, okay, well, we'll be able to move out, in the really soon 1 day to 5 day range, and you can get some concessions for your client by making that agreement, including guarantee that they get their full security deposit back. That's always a very nice one, and maybe even some extra money, kind of a cash for keys, as they call it, situation. So they get paid $200, $30, whatever it might be, to guarantee that they'll be out, by the weekend or whenever it is, and some landlords like that. Any questions on settlements before I move on?
No questions on settlements.
Okay, good. I'm moving on. All right. Underlying basis for eviction. Okay, we're getting into the real nuts and bolts of things here. And yeah, we're going to go over basically everything, certainly everything that you will regularly see. And feel free to try to throw me a curveball if there are any experienced housing law attorneys here that want to trip me up. That's always fun. But here's an overview of things as I see them. You have non-payment of rent being, an obviously very big one, and breach of lease. Those are really the two big ones that you see out there often. There's statutory violations. There's written in statute, even for oral leases, certain reasons that the landlord can evict if there's certain illegal activities happening in the unit that they can evict for. Holdover, basically the client was on a year-long lease. They did not renew their lease, and they said they were going to move out, and then they didn't move out. They're a holdover. If they're in a month-to-month tenant and the landlord gives them the 30 days notice that we're no longer renting to you, 30 days come up, they can't come, they don't leave, they're a holdover. And then you have kind of these catch-all at the end, the squatter, the foreclosure, contract for deed cancellation cases, these ones that you're not even sure, is this person a tenant at all? We'll talk about that. Okay, non-payment. So I am going to be engaging and asking you, the audience, right now, think and also type. What are some defenses to your client being accused of not paying the rent and therefore they should be evicted? I will wait and type into the chat, please, so everyone can see it. Think. And I know this might not be area law. There's no wrong answers here. You're doing great. Excellent. Habitability issues, I see. Yes. Ooh, good. Acceptance of partial rent. No receipt of payment. Yeah, they don't owe the money. That's a beautiful one. No, these are good. These are good. I'll wait just a moment, see if any more trickle in. Yeah, so we got some great ones here. you know, the underlying thing is the landlord claims that they owe money. They might not actually owe that money. Yeah, and you can always contest the ledger. And yeah, the fact that there's no receipts of payments that always just muddies the water. Joint and several liability between roommates. Yeah, that is not that is almost always the case. But yeah, if you somehow had a lease where the multiple roommates were not jointly and severally liable for their respective roommates' rent, and they tried to evict everybody because one roommate did not pay it. I've never seen that, but that is possible. Let's take a look at some of the ones that I have here. Yeah. So subsequent payment, and you can call this waiver. You can call this partial payment. Yeah. That if someone owes rent and they then later pay all of it or pay partial, unless there's a non-waiver clause in the lease, that the landlord is waiving their right to evict for non-payment of rent because of that. We talked about rent help applications. I did mention this before. So there is the very tail end of the eviction off-ramp laws are still in effect, and the only vestige of that left is that if a tenant has a pending application with Rent Help Minnesota or any other qualifying rental payment group, then they cannot be evicted for non-payment of rent. This will go through May of 2022, May of this year. Then this will no longer be an issue. But do know that you don't quite see as many of these anymore, so this is going to become less and less of a thing. Other notice requirements. I mean, I mentioned this course before, but specifically for these Minneapolis and St. Louis Park, these notices actually, I believe they only apply to non-payment cases. So they don't even require notice for other cases. But if it is a non-payment of rent case, then you have to have this notice. Redemption. So usually this doesn't happen for our clients with their income as low as it is. But just in general, if, even up to the day of the court, even up to the day that the writ would be issued, they're allowed to redeem. So if they can pay back all their back rent plus all of the late fees and all of the attorney's fees and court filing fees, the landlord has to accept it, and they've redeemed their lease. And I believe habitability issues. So yeah, my repair is needed. So this is known as the Fritz defense for eviction cases. That and the reasoning of the case is if there have been these repair issues that are needed, then maybe the money that the landlord claimed should be owed, the full rental amount, is not actually owed because that rent should be abated due to these habitability issues. If you are going to assert a Fritz defense, know that your client has to put all, or at least this is the standard interpretation of Fritz, and can be argued against, but needs to put all of their back rent owed into escrow with the court. It's just like a rent escrow case in that sense. But if they're able to do that, if they're able to escrow all of their back owed rent, and I believe that would not include any court fees and probably not any late fees, then there's got to be hearing on these repair issues and determine whether or not rent abatement is warranted, and therefore is less rent owed, and therefore the individual is not behind in the rent. Excellent. Okay, I have just one more of these. You've all been great talking about breach of lease. And we can all put on our law school hats, remember back to contracts and how a breach of contract, because that's all a breach of lease is just a breach of the contract between the landlord and the tenant. So what are the defenses if someone is accused of doing some sort of action that's a breach of lease? What do we want to think about? What is an action that can save them, so that you can say that no, they should not be evicted for this breach of lease? Beautiful. Timothy Rank says, not a material breach. This is a key point, and we'll talk about it. That it can't be just any old breach. It needs to actually matter. And I have a fun story about that as well. I'll wait just a moment for any other thoughts on breach of lease. Okay, let's take a look, see what the survey says. Okay, first and foremost, is the alleged breach even in the lease? This is the most important question. And you would be amazed how many times that it's not. Like, they're being kicked out for, I don't know, fighting too much. And you look at the lease, it's a very simple lease. There's nothing in there about says that you can't fight. So it's not a breach of lease if it's not written in the lease. And then similarly, a point that you really want to comb through that lease is there what's called a right of re-entry clause. And the right of re-entry clause is this other contractual aspect that you need. So not only does it say that you can't, say, get into fights, and that if you get into fights, but not only that, it must say that, and if you do get into fight, then this will be considered a breach of lease that you can be evicted over. And it needs to say that. It needs to say that, and it can say it very generally, basically saying that any breach of lease we can evict you over. But yeah, and it needs to specifically say that eviction is allowed because of breaches of lease. And so if you have these kind of handwritten leases written by pro se landlords, it will often not have this. And then we get into the issue material breach. Is this actually a big deal? Yes, they damaged the property, and it does say in the lease that you can't damage property, and it does have the right of re-entry clause saying that you can evict someone for damaged property. But the damage was, they, broke a light bulb that's in the public hallway. A broken light bulb is not a big deal. You can sweep it up with a broom and you can get a new light bulb. That is not material. And then another thing you want to do for any sort of contract or any breach situation is, do they have the necessary state of mind? So like, did they intentionally or negligently do this breach? And I've won cases on this. I had a situation where clients were renting from a downtown apartment complex. There was an underground garage, and their car slid on the ice and impacted the garage door, and they were being evicted for breach of lease for damaging that garage door. And the 2 points that I hit on was like, how much damage was actually done to the garage door, and that was a big issue, which again would go towards the materiality of like, was this actually a big deal? But then two, did they hit the garage door on purpose? No, they slid on some ice and were trying their darndest to not hit it, and there was no allegation that they were otherwise driving recklessly. And the judge agreed with me and said there's no evidence that this was done on purpose, and we don't consider this therefore a breach in the legal sense. And then lastly, you can also waive breach of lease issues. Did they accept rent afterwards? And this is important. If at some point, for whatever reason, the landlord wants to kick someone out, this happens all the time. They will rack their brain for reasons to kick this person out. And they go, oh wait, yeah, last summer, they got into a big fight and something happened, and I'll kick them out over that. But this happened, back in August. Did they accept rent in September and October and November? Yes, they did. They have waived their right to try to evict them for that breach of lease. All right.
Okay, Sebastian, a couple questions. Does it have to be specified that it is a material breach of the lease in the lease document?
No, it does not need to specify that. I mean, I can interpret this question a couple of different ways. Like, it's sort of like a liquidated damages claim. Like, could they say that if you do X, it is de facto a material breach of lease? That's an interesting question. I'm not certain. I would certainly push back against that and say that, but no, like it doesn't need to say that, it doesn't need to use the magic words material breach in the contract for it to count for the right of re-entry clause or anything else.
And then in a divorce case where there is an order for one of the parties is ordered to vacate within a specified time and she stays beyond that date, is the service of order sufficient notice allowing other party to bring eviction complaint?
Yeah, I mean, I would argue that it is. You always want to, use a belt and suspenders approach. So if you have the ability, it's always good to serve them an extra notice just to be sure. But no, I believe that if you have a judicial order that says this property belongs to someone else, you have 30 days to move out, and you can show that they got, were served that order from the judge, that would be sufficient. And that would therefore be a holdover case. And this kind of falls into my miscellaneous category at the end there, which we'll talk about, because they're not really a tenant. They could argue that they are, but you certainly think of a hypothetical and what this person is not a tenant. They're just like kind of there, and you still have to go through the necessary eviction process, but it sort of changes the calculus a little bit. So we'll talk about that a little bit more in a moment.
And then with Fritz defense to non-payment, can rent due be paid after the initial appearance?
Yeah, I believe that if you raise it at the initial appearance and you say, Your Honor, we're going to be raising a Fritz defense, and we think that there are habitability issues that will affect how much that my client actually owes. I think that the judge or referee would give you, a couple of days to get it in there. It doesn't need to be in like that moment, but it needs to be in quickly, right? But yeah, it probably doesn't need to be in by that first appearance. Okay. This is the statutory violations. You don't see too many of these, but it's always an option. It's sort of like the equivalent, for those of you who do rent escrow cases, sort of the equivalent of 504B.161, that like this is reading in certain requirements into leases that aren't written there. Even an oral lease has these provisions basically saying that if a tenant does any of these illegal actions, that is a cause of action to evict them. And it's like, it's its own aspect in the lease, and its own right of entry clause right in the lease for these type of actions. And what are they? It's your standard sins here: your drugs, illegal drugs, guns, prostitution, stolen property, domestic violence, sex crimes, and harassment. Those last ones are kind of tied in via another statute. So if you have specific questions, when you read 504B.171, it'll reference some other actions from other statutes, and you read those in there. But it does include them. You do see these on occasion, especially the drugs and guns one I see with some frequency. So what to do with these? Okay, so one, watch for vague allegations. If they just say like defendant uses drugs on premise, they're not specifying a specific day and a specific time. It is, it's a signal that you can fight this, and maybe that the landlord really doesn't have any hard and fast evidence of when this took place, where, and similarly, do look at the 504B.171 about, it's very specific about the things that it is saying it's not allowed, and so just go through the statute with a fine-tooth comb to make sure the allegations match up with the statute, because they might allege some things that don't really fit into there. And then lastly is the knowledge requirements. So, they might allege that, oh, there was a party and the cops came and someone was, arrested for possession of a firearm. Therefore, I'm evicting you, the tenant. But it wasn't your tenant who was arrested for possession of a firearm. They didn't have any knowledge that this person, like, they were their guest, true, but you need to have specific knowledge about these, like possession of drugs, possession of illegal firearms, and you can certainly fight those in court, and give yourself a strong bargaining position. For example, if again your tenant or your client decides that they're not really interested in sticking around there, these can be very weak allegations, so you should be able to use that as a strong bargaining position to get a good settlement.
Question just came in regarding the issue of drugs, guns, harassment. Is there a standard of proof that is codified or otherwise required?
Yeah, I mean, it is, I believe all of these are preponderance of the evidence standard. So more likely than not that these things happened, which again is not, sadly, the best, that is one of the easiest, right, to get against your client, which is too bad. But still, you can still defend it with even if that weak of a standard. But yeah, preponderance of the evidence for basically all of these, the breach of lease claims as well, all of it. Holdover cases. So holdover is anytime, yeah, that you're a tenant is legally renting a unit, and then they should leave because their lease ends. They've been given notice to leave for whatever reason, and they don't leave. Then they are a holdover. So how to defend against these? So a lot of these, especially to ending a lease or ending a month-to-month tenancy, that does require notice. It needs to be written notice, and you know, people can mess this up again, especially your pro se landlords. And then similarly, as with other ones, waiver by subsequent rent acceptance is always a good thing to bring up, basically for everything. I'll pause for any questions on holdovers.
Can an email or text be considered in writing?
Yeah, I mean, you could argue that it's not, but no, I think that yes, email and text is in writing. Certainly when it's my client who's giving some sort of notice by email or text, I would definitely argue that is in writing and is proper, even if it's not the traditional, handwritten letter. Okay, and the last one, I'll just go over these quickly. Squatters, foreclosures, etc. First question is, are these people tenants, especially if they're being accused of being a squatter? And if there's consideration of any kind, even if they're not providing monthly rent, but if they're contributing to the household in some sense of, they chip in for the Netflix account, or they, do dishes every week, that's a good way of arguing that they are tenants. And this mattered more before, when we had a lot of protections for tenants under the eviction moratorium. Not quite as important these days, but always a good finding to have from the judge. But as a reminder, if you have a foreclosure case or a contract for deed case, you cannot contest the underlying basis of the foreclosure, the contract for deed case, in the eviction proceedings. They need to go back into the foreclosure case or the contract for deed case and bring those issues there. Basically, the only thing you can really do for it, someone who had their house foreclosed on and now they're being evicted, is get a good settlement or maybe argue bad service, and that's what you have in front of you. Okay, my last section now, discovery, evidence, and trial. And I know we're getting a little close to the end here, so I want to make sure to get through this. Cases go quickly. Here is an example of one that actually happened. First appearance on a Tuesday, discovery deadline a week following that, trial a little over a week following that. And it depends upon the openness and availability of the court's calendars, but that's what we're looking at here. Things go quick. And discovery is quick and it's informal, and it's usually limited to a witness list and an exhibit list, and of course the exhibits themselves. That's not to say that if you wanted to, you could not serve interrogatories on your opposing counsel. You can do that. I've gotten that one time. Or I've never seen any sort of depositions. That would be something. But this is standard practice, is just that, send over your witness list and your exhibits, send them to the court, a couple of days before trial, and boom, you're in there. And just thinking in general about, hearsay, this is not officially written into any rules, but in my experience, the referees can play pretty fast and loose with hearsay issues. And they say, well, maybe it's hearsay, but I'm going to allow it and hear it anyways. And I'll take it, with a grain of salt. And you got to say, okay, judge. And some trial and pre-trial tips. And these are, I talked to my colleagues about this and got some good things. So number one, file an answer to, and if you're going to trial, file an answer with all of your defenses on it. This is going to help, the judge follow the flow of your case to know what defenses you're going to be raising before they get raised, and it's just a good way to have that in writing. Settlement talks are going to be happening right up to trial. Even the day of trial, it's very possible that the referee or the judge is going to throw you into a a breakout room and see if you can work it out last minute, counsel, before the trial happens. And take advantage of that and see if you can work something out. Because yeah, a lot of times settlement deals that the landlord was not willing to accept on the first appearance, they might accept here because trial is a crapshoot and you never know who's going to win. Similarly, the courts are going to ask you to agree to exhibits in advance. This is a nice way to streamline trial, but you do not need to agree to anything. And don't feel pressure to do that. And also consider if you see some exhibits or some witnesses that are questionable and you think should not be allowed, consider doing an oral motion in limine right at the start of trial and just get those issues taken care of. Other notes. Okay, so know the landlord claims, know the elements of what they need to prove, and attack them. If it is a breach of lease, it needs to be material breach of lease. We said that before. I'll say it again. And there's your citation that allows that. If they're alleging those statutory claims, they need to meet all the elements that are laid out in the statute. For your affirmative defenses, keep those in mind, and you want to start raising those right away during cross-examination of the plaintiff's witnesses. Good thing to note, property managers or other, whatever witnesses that the other side is going to get, they may in fact not have firsthand knowledge of what they're testifying about. Property managers may not have been on the scene, the night that the fight occurred, or, so note that, object as needed, object to hearsay, object to foundational issues as much as you can. And here's, several issues, police reports, drug reports, ledgers that you see. All of these things can be need foundation and can be excluded. All right, so I've reached the end, everyone, just in time. This is my email, Sebastian Ellison at VLNMN, like Minnesota.org. Please do reach out to me if you have any questions. I love talking about eviction matters. And if you have a case, I'm happy to talk about it with you. And of course, if you do take a case for VLN, then I'm extremely happy to talk about a case with you. And we will help you every step along the way. And visit our website, find our checklist. It's downloadable. You'll have all of an outline of like the first 3/4 of this presentation is in checklist form, so you can go through as you're going over advising or taking your first case. Okay. Thank you so much. Any further questions?
Yeah, a few questions. One was, can rent include things other than money for waiver?
Yeah, it's certainly arguable. If the client pays, client is on the hook for paying utilities. Is the fact that they paid utilities a waiver? No, I would not say it is, because it's not the landlord who's accepting that. But if they're paying the landlord some sort of money for something that would be considered outside of rent, then yeah, you could say that that's a waiver if it's part of the lease.
And if there's time, this person would like to hear more about failure to accommodate a disability as a defense to eviction. How does that work in practice?
Yeah, you could definitely have an entire presentation about that. And I'm not really an expert on that disability issues. I mean, if those come in and there's like a really clear disability defense, VLN will usually refer that out to attorneys that we know are, more versed in that. But generally speaking, if a client is in a place and they say that, oh, I need to have, a service dog because, it's a reasonable accommodation of my disability, whatever it be, I mean, blindness being a very obvious example, but other ones where you need a service animal. And the landlord says, no, you can't have no dogs allowed. And the client gets the dog anyways, and they're evicted because it says, no pets is in the lease and it's a breach of lease. Well, that would be a case of not doing a reasonable accommodation, and then that would be your defense against that breach of lease claim. Or if they were, I mean, this kind of goes towards retaliation as well, but if it's retaliation for asking for reasonable accommodation, those tie together. But yeah, if you encounter one of those, you can one, look at the statutes. You can talk to us. We will have other lawyers we could refer you to that could really be experts in that area. Okay. Well, we have reached our time. It is noon. I thank you everybody for coming. Know that we do have advice shifts that you can sign up for. You want to get your toes wet with this, we can shadow you, you can shadow us. It's always a really very valuable to do, and you see the effects of your work right away. You negotiate that really good settlement that gives your client, who's in a desperate situation, gives them another month and a half at their place, so they can save up their money and they can get a new place. It's just always a wonderful thing to do. So I do hope that we hear from you. Thanks for so much for coming, and have a wonderful weekend.